It is submitted that the allegations against the applicant are very grievous in nature, as the applicant has conducted himself in a rude and discourtesy manner. Further, the applicant has released the phone record conversation and made it viral on social medias. It is submitted that the conduct of the applicant was against the service rules. It is submitted, and considering the gravity of the conduct, the applicant was placed under suspension. He is asking for illegal construction in the forest area, about which FIR is already filed. Privilege exercised by the members.
MLA will get exposed now.
But
Having regard to the telephonic call, Mullars, he made it circular, Mullars, in the social media. That is call
exactly the
record.
Call
allegation.
between.
Please.
No, that is exactly the allegation before the CIT. They proved.
Why did you?
No. I carry
publish
iPhone. It is
social media?
those. No. I have completely denied it. They could not prove before the CIT that I recorded. That is the very foundation.
No. Suspension was on that ground.
The only on that ground.
Idರಲ್ಲಿ objections,
reason
Mullars.
The state government
Only for
filed the
formality.
objections before the CAT. Now they cannot improvise. Kindly see page 48, Millard. Page 48 of the repetition. They've already indicated the stand before the CAT. And Millard, they got brickbats by the CAT for their attitude. It is submitted that the allegations against the applicant are very grievous in nature, as the applicant has conducted himself in a rude and discourtesy manner. Further, the applicant has released the phone record conversation and made it viral on social medias. It is submitted that the conduct of the applicant was against the service rules. It is submitted that the respondent to, having pursued the material and record, and there was a prima facie material, and considering the gravity of the conduct, the applicant was placed under suspension pending. This is the exact ground of Annexure A. Now kindly see Annexure A, Millard. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖಿತ ಪತ್ರದಲ್ಲಿ ಐಎಫ್ಎಸ್ ಉಪ ಅರಣ್ಯ ಸಂರಕ್ಷಣಾಧಿಕಾರಿ ಘಟ ಮಾನ್ಯ ವಿಧಾನಸಭಾ ಸದಸ್ಯರಾದ ದೂರವಾಣಿ ಕರೆ ಮಾಡಿದಾಗ ಅವಾಚ್ಯ ಶಬ್ದಗಳಿಂದ ಏರುಧ್ವನಿಯಲ್ಲಿ ಏಕವಚನದಲ್ಲಿ ನಿಂದಿಸಿ ದೂರವಾಣಿ ಕರೆಯ ಬಗ್ಗೆ ರೆಕಾರ್ಡ್ ಅನ್ನು ಮಾಧ್ಯಮಗಳಿಗೆ ವೈರಲ್ ಮಾಡಿ ಹಕ್ಕುಚ್ಯುತಿ ಮಾಡಿರುವುದಾಗಿ ತಿಳಿಸಿರುವ ಪ್ರಕರಣದ ಬಗ್ಗೆ ಆದ್ಯತಾ ಸಮಿತಿಯು ಸೋನ್ಸೋ. Now, Millard, I am not disputing the privilege of a member of Legislative Assembly. What is to be considered is, where did he exercise that power? He called an IAS. He is not the minister in charge. He calls an IFS officer to permit illegal construction in the forest area. Kindly see the next page. Even before I took charge as the deputy conservator of forest, a FIR was registered against one Mr. that he ರಾತ್ರೋರಾತ್ರಿ ಹಸನುಗೊಳಿಸಿ ಕಟ್ಟಡ ಕಟ್ಟೋಡ ಸಲುವಾಗಿ ಗುಂಡಿ ತೆಗೆದು ಕಾಲಮನ್ನು ಇರಿಸಿರುವ ಬಗ್ಗೆ ಪತ್ತೆ ಹಚ್ಚಿ ಗುನೆ ದಾಖಲಿ. This person, he pestered continuously to permit the construction in the forest area. Now several persons called me impersonating Mr. Day, that is on January 9, 2024. Another call came saying that he is MLA. He said, what do you want? I said, please permit the construction of this structure. I said it is not permissible because under Forest Conservation Act, central enactment, permission is required. The fact that he called the petitioner for an illegal purpose, kindly see page 5.
55.
This is the objections filed before the CAT. It is paragraph 6. It is most respectfully submitted that during the conversation, respondent 5 was requesting the applicant to permit construction of a forest building, in respect of which FIR was already lodged by an earlier officer. Now, how this is dealt by the CAT? Kindly similar page number 77. Now, this order of the CAT has become final. Simply reading of Annexure 8 shows that only fact in the case to be verified as to is already accepted fact that there was conversation between respondent 5 MLA and the applicant on the designated day, which is accepted by the applicant. He may have harshly talked to him as the circumstances were such that it was a case of enforcement of Forest Conservation Act and related provisions of the law, and people were impersonating MLA and trying to influence and interfere with the work of the public servant. In the instance case, the real MLA also talked to him, and it is not clear whether the MLA was inquiring about the facts of the case, or he was trying to influence the case. Why did he have the occasion to interfere with the quasi-judicial functions of the applicant? There has to be an arm's length distance between the members of the legislature and the enforcement authorities in the field. And if at all, such enforcement act with encroachment of forest land was involved and the FIR was already registered, a member of legislature has to talk to the authority. Did he not require the exercise caution and restraint? In such circumstances, the rightful way would be to approach the forest minister or ask information as provided in law, as there was various provisions of the law for asking them in the assembly to call attention or through question or other means, but not directly touching the base with an enforcement authority who can be unduly intimidated and influenced by such encounters. Now kindly see my lord, page. This incident could have been a good case study to develop a training module for the officers as to how to deal with political interference at the field level in the difficult job of forest conservation and enforcement of forest laws relating to unauthorized encroachment of forest land. The incident could have been triggered the self-imposed conduct by the members of legislature.
Now,
Yes.
what is initiated?
Now
against
what they've done is the suspension order was quashed.
Ah.
Now they have initiated privilege motion against me. Now Sita Soren, my lord, the constitution benchment of the Supreme Lord, your lordships are aware. Like the famous American doctrine, what happens in Vegas stays in Vegas. What happens in assembly stays in assembly. But he comes out and shouts at somebody.
ಅದೆಲ್ಲ ಅಲ್ಲ, ಅದೇ ಕಾಂಟ್ರವರ್ಸಿ ನಡೀತಾ ಇದೆ ನಮ್ಮಲ್ಲಿ.
ಅದಕ್ಕೆ ನಾನು ಅನ್ಕೊಂಡೆ, if he had said inside the assembly, if I have gone inside the assembly, I can understand. He had no business to talk to an IAS officer to permit construction in a forest area. That is nothing to do with his performing anything in the assembly. Suppose somebody speaks something in the assembly, that is protected, whatever it is, even to the extent of that your lordships are considering, whether you extend to the extent of physical altercation or verbal altercation. That's an entirely different thing. But an MLA calling an IFS officer, please permit construction of illegal activities in the forest area, that is something which is beyond the scope of Article 194. Kindly, I'll only read one paragraph, my lord, in the Supreme Court judgment in Sita Soren. I think, my lord, the judgment was passed on to your lordship.
Here it's here.
Yes, my lord. There, my lord, kindly see paragraph 84, 82. My lord, the privilege aspect is concerned, my lord, I do not dispute. They may have privilege. For example, he has asked for the release of the food.
This is not spoken in this session.
No. My
Uh,
lord, assuming for a
Of privilege
yes,
motion.
assuming for a moment that I am a DDPI, that I have prevented distribution of the food to the children in the afternoon, like eggs, sir. He has every right to call upon me and
There.
yes, he can ask me why he have stopped distribution of food. He is asking for illegal construction in the forest area about which FIR is already filed. Kindly see paragraph 82. The privilege exercised by the members.
MLA will get exposed now.
Pardon, my lord?
What made Mullars, having regard to the telephonic call Mullars, he made it circular Mullars in the social media. That is the Mullars. That's why this
But
the call record, call
Exactly the
record.
call
allegation.
between,
Please.
No, that is exactly the allegation before the CAT. They proved.
why did you?
No. I carry iPhone. It is
Social
in-
media?
those. No. I have completely denied it. They could not prove before the CAT that I recorded. That is the very foundation.
No, suspension was on that ground.
The only on that ground that I recorded and Lord, I have heard the conversation. The entire conversation. The anchor attacks me.
Your suspension was based upon the circulation in the social media of certain conversation, correct?
Number one, making scurrilous attack against the MLA,
Hmm.
and second one is recording and releasing to the media. Both, my lord, they could not
Where
prove.
is the order of suspension?
Lord, kindly see the order of suspension. Is at page number 26. Identical grounds. Lord, it appears they initiated the proceedings simultaneously and thereafter the notice came.
Order of suspension,
Lord, page number 20,
same grounds.
same grounds, identical grounds. And I circulated. They could not prove it. Yeah, as a matter of fact, before the CAT, they did not.
Suspension set aside, so it's privilege motion.
Privilege. Formal objection, Mullars.
No, they made they stand very clear before the CAT that is that I.
No, the order pass ಮಾಡಿದ್ರೆ then appeal ಅಲ್ಲಿ ವಾಪಸ್ ಬರುತ್ತೆ. Objection ಹಾಕಕ್ಕೆ ಅವಕಾಶ. We'll post it for further hearing. Heard the learned senior counsel hearing for the petitioner. The learned senior counsel takes this court through the documents appended to the petition to demonstrate that the abuse of power available under, to demonstrate, prima facie demonstrate abuse of power under Article 194(2) of the Constitution, 194(2) of the Constitution of India. The learned senior counsel submits that based upon the alleged circulation in the social media of the conversation between MLA and the petitioner led to the passage of the order of suspension on 21st February 2024. The Central Administrative Tribunal, by a detailed order considering these aspects, holds there was no allegation against the petitioner that could have led passage of the order of suspension. The order of suspension is quashed. Immediately thereafter, the member of the Legislative Assembly appears to have moved for a privilege motion holding that it is in violation of the Constitution and the immunity that the MLA would, a member of the legislative assembly would enjoy. The matter would require further consideration, for which the filing of the statement of objections for the state is imperative. The hearing, interim order subsisting, will continue to the next date of.